The next case on the call of the docket is agenda number 4, case number 124818, People, the State of Illinois versus Kevin Jackson. Mr. Clark, you may proceed.
Good morning, Your Honors. Brandon Clark on behalf of Appellant Kevin Jackson. With me today is co-counsel Elizabeth Bacon. May it please the court. Today, we ask that the court reverse the First District opinion below, grant Mr. Jackson leave to file a successive post-conviction petition. This would be his second post-conviction petition and his first with the benefit of counsel. The court's standard of review of the relief that we're seeking is de novo. There are 3 issues before the court here today. The first is whether this court's decision in People v. Hobley requires that evidence of actual innocence be siloed off from evidence of cause and prejudice, as the decision below put it. The second issue is what is the appropriate standard for relevance of evidence of police misconduct? And the third is whether sufficiently conclusive evidence of actual innocence should be evaluated by a relaxed standard of newness. I'd like to turn first to the issues raised by People v. Hobley. People v. Hobley is an anomaly in this court's jurisprudence. It has always been in tension with this court's decision in People v. Washington, which held that it's unconstitutional to imprison an innocent person given compelling evidence of actual innocence. And Washington explicitly rejected the dichotomy of actual innocence claims that Herrera v. Collins relied on, the so-called freestanding versus gateway claims of actual innocence. Nevertheless, in Hobley, this court ruled that evidence that supported a Brady violation and therefore a cause and prejudice claim could not also support an actual innocence claim because that claim would not have been freestanding. Later on, though, this court in People v. Coleman was very clear in rebuffing an argument by the state that Washington had been wrongly decided. This court said, and I quote, "This argument rests largely on a faulty initial premise. The state simply assumes that this court, like the Supreme Court of the United States, has recognized two types of actual innocence claims. It has not," end quote. Nevertheless, the First District felt what it said was compelled by Hobley to reject Mr. Jackson's actual innocence claim because it was not freestanding. This court had sound reasons to reject Herrera. It led to a real injustice, and this court evaluated it closely in Washington, and with the exception of Hobley, has repeatedly rejected opportunities to return to a more Herrera-like dichotomy of freestanding versus actual innocence claims. Therefore, the First District below was wrong to consider itself compelled under Hobley to reject Mr. Jackson's actual innocence claim, and this court should reverse on that basis. We would ask that the court also take this opportunity to clarify the current status of People v. Hobley. And to reiterate, as it has done multiple times, including in People v. Ortiz, that all actual innocence claims are cognizable under Illinois law, and that there's no restriction on the evidence offered to support either actual innocence or cause and prejudice. The second issue I'd like to discuss with you, if there are no questions on the first.
And the first issue, counsel, doesn't it come down to the actual definition of an actual innocence claim, though, whether we're talking about total vindication as opposed to whether or not a defendant has been proved guilty beyond a reasonable doubt? So the hallmark of an actual innocence claim is one of total vindication, not challenging some aspect of the evidence that was adduced at trial.
Your Honor, that's not actually how I read Herrera, although I don't know that my reading of Herrera is of much value to the court, since this court rejected that dichotomy. As I read it, though, the issue is that in order to bring a successive habeas petition in federal system, petitioner cannot simply allege that they're actually innocent. There must have been some trial error. As this court recognized in People v. Ortiz, it's almost impossible to imagine that a claim of actual innocence would not also satisfy cause and prejudice that there would not also have been some sort of trial error in order for there to be an actual innocence claim. And so I think that goes to the issue of whether of this total vindication. Mr. Jackson's claim is that he is, completely innocent, not that he should have been found guilty of some lesser included charge, not that he didn't have the correct state of mind. His claim is that he's truly and actually innocent. And I think what the state argued below, although I'm not so sure that their brief here touches on it, perhaps counsel can clarify when I've completed here. But my understanding is that they are not arguing that this is a sufficiency of the evidence sort of claim, or that it's not a complete vindication, but simply that there's been an insufficient showing of actual innocence here. And I think that my next point to the strikingly similar standard that the first district applied really defeats that argument. I hope that answers your question, Your Honor. Okay, thank you. So turning then to the strikingly similar standard that the first district applied to Mr. Jackson's evidence of police misconduct. Normally, the relevant standard under the Illinois Rules of Evidence would be that evidence is relevant, as we all know, if it has any tendency to make a fact of consequence more or less probable. And while post-conviction proceedings are explicitly exempted from the Illinois Rules of Evidence, and as this court has recognized in People v. Allen and I believe other decisions, that evidence need not be admissible in order to be relevant and probative of a post-conviction proceeding. Nevertheless, I think that the rules of evidence are helpful in guiding the standard that should have been applied to Mr. Jackson's evidence. And rather than relaxing the standard as required by Illinois Rule of Evidence 1103b3, which exempts post-conviction petitions, the first district has instead applied a heightened standard, what they call a strikingly similar standard, which purportedly comes from this court's decision in People v. Patterson. However, I think—
What is the definition of strikingly similar?
It is not defined, Your Honor, and that is part of our contention in the error and the folly of this standard, is that it is not defined. I could give you a dictionary definition of strikingly, and yet I don't know that it would get us any closer to fleshing out what this standard is. I would note that the first district started from a standpoint of evaluating the evidence from a modus operandi framework. And for that, under Cruz, there's still not a strikingly similar standard. This would seem to be a higher standard even than that. Under Cruz, what's necessary for a modus operandi showing is a high degree of identity, and yet still allows for some dissimilarity. Here, as applied by the first district, at least in this case, strikingly similar is even higher than that. In particular, the first district was evaluating the similarity of evidence between the case of Bridewell v. Eberly, which involved one of the lead detectives in Mr. Jackson's case, and the allegations in Mr. Jackson's case. In Bridewell, the detective stipulated that witnesses went through long interrogations, that the detectives withheld food and water, that they were subjected to verbal abuse, that the police threatened to charge the witnesses if they didn't provide statements helpful to the police, that they threatened to take away their children, take away custody of their children, and that they used biased polygraph examinations. All of this eventually ended up in not resulting in any sort of liability for the officers for procedural reasons. However, I would note that the Seventh Circuit, in affirming that dismissal, noted that this conduct was, quote, deeply disturbing. So to say that it exonerated the officers, as the state has, is factually incorrect. Now, with all of those allegations that are actually no longer allegations, all this conduct that was stipulated to by the officers, I think it's important to look at the allegations in Mr. Jackson's case. Brandy Grant said that she was threatened with custody and charges while she was pregnant, which would necessarily have separated her from her children. Vernon Clay was subjected to a 33-hour interrogation and verbal abuse, and was held the right to counsel or phone call. Manuel Stewart was threatened with the loss of custody of his, as of then, unborn children, and was subjected to a biased polygraph examination. This is near identity with what was alleged and stipulated to in the Bridewell case. And yet the first district said that this is not strikingly similar. This is a much too rigorous standard to hold police evidence to, particularly in light of post-conviction petitions exemption from Illinois rules of evidence.
What do you propose the standard to be? Just mere relevance?
So I think that we easily satisfy the relevant standard. And so I don't know that this court today needs to decide what the correct standard is. I think that just mere relevance would more than suffice at this point.
The appellate court majority talked about, at least in one paragraph, a pattern and practice of the same or similar conduct by the same detectives. Would that satisfy you as far as the standard is concerned?
I think that if this court, chose to go that direction, that there would be, certainly good basis for that, and that we would satisfy that as well. However, I think it ignores, something I was going to come to in just a moment, that even without showing, a pattern and practice or a modus operandi or any of these sorts of things, these somewhat heightened standards ignore that there are a number of other reasons that this sort of misconduct could be relevant to the proceedings. It could be offered to show motive, opportunity, absence of mistake, all the things that would typically be allowed in under a past crimes exception under 404B. And in particular, when we're talking about police misconduct, I think motive is critically important. And the reason is that police misconduct is driven by a desire to obtain evidence that will support convictions. It is absolutely motive driven, and evidence that the same officers in prior settings have engaged in misconduct for the purpose of obtaining evidence that was either shown to be false or even alleged to be false, I think is incredibly probative to not only Mr. Jackson's case, whereas the court below recognized it truly turned on credibility determinations, but in any case where there are allegations of police misconduct, it goes to the integrity of the officers, which is always at issue at a criminal trial, particularly when they testify, as several of the officers did here.
Is it your position then that the claimed improper conduct by the officer doesn't even have to be similar as long as it was improper conduct?
And I'm not sure that this case presents a particularly good fact pattern to make that decision, because the conduct is so similar between Bridewell case, the Patterson allegations, several of the CRs that we've identified. I think we have such similarity that perhaps this doesn't present a great test case. However, hypothetically, I could imagine police misconduct that would not bear on particular allegations. For example, if all of the officers here had only ever been, alleged to have engaged in misconduct outside of their commission of their duties, if they had perhaps DUIs, to pick an example, perhaps that wouldn't be similar enough. But where you're talking about misconduct that really goes to the integrity of the investigation, I'm not sure if it does matter if it was witness coercion or suspect coercion or planting evidence or any other means of corrupting the investigative role that police officers play. Which calls to mind actually a quote from a case in our briefs that I think is really instructive on this matter, even though it is related to torture cases. But Justice Wilson, or then Justice Wilson, and People v. Cannon recognized that minor differences in the technique do not alter the nature of the torturer's work. Now here, to be clear, we are not alleging any torture took place, but minor differences in the misconduct of these officers in developing what is alleged to have been completely false evidence does not alter the nature of what it was that they were doing. And to focus on these minute differences, some of which on closer reflection of the record and the allegations in some of these cases don't even exist. For example, I believe the court below held that or found that there were no threats of charges against the witnesses in Bridewell. That's not borne out by review of the Bridewell record. So these minor differences just don't weigh enough against this evidence of misconduct to exclude it altogether. So for that reason, we think that the strikingly similar standard has no place, has no basis in this court's jurisprudence, and in this case certainly led the court below to an unjust result. And so we would ask that the court reverse on that basis and clarify the standard by which police misconduct evidence should be considered in a post-conviction proceeding. The third issue I want to discuss is the affidavit of Ms. Davis. Now, it's often stated, certainly by this court and others, that an actual innocence claim requires that evidence be, quote, newly discovered, that it be material and non-cumulative, and that it be conclusive. However, this court and courts below have stated frequently that the most important factor is the conclusiveness of the evidence, which begs the question, suggested as a disjunctive test, and begs the question, when is evidence sufficiently conclusive to evaluate it under a relaxed standard of newness? As Justice McMurrow said in her concurrence to People v. Washington, finality must yield as a matter of fundamental due process to the manifest injustice that would result from the continued incarceration of a demonstrably innocent person. To be demonstrably innocent, a person must have conclusive evidence. And if it is sufficiently conclusive evidence, it should not matter whether that is new evidence or not. However, the court doesn't need to decide that here today, although we urge that it should clarify what it's meant in its past decisions by stating that the most important factor is conclusiveness. But rather, all the court needs to determine today is whether in this case, where Ms. Davis's testimony has never been considered by a court before, and where her Mr. Jackson's counsel's failure to call Ms. Davis at trial was part of an earlier post-conviction proceeding for ineffective assistance of counsel, whether that renders her affidavit, quote, newly discovered. And I continue to say, quote, newly discovered, because it truly is a term of art that's been given meaning by this court's jurisprudence and does not necessarily mean in all instances that it is entirely new or newly available or newly in existence is what I'm trying to say. There have been a number of instances where evidence that's not been available previously has been treated as newly discovered. And under the circumstances of this case, we would urge the court to explicitly find that Ms. Davis's affidavit, it should be treated as newly discovered. And with that, I note that I'm almost out of time. And if there are any questions from the court, I'd be happy to answer them.
Amen. Thank you, Mr. Clark.
Thank you.
Lula, you may proceed.
It please the court, counsel. I am Assistant Attorney General Michael Sabula on behalf of the people of the state of Illinois. This court and the legislature have repeatedly made clear that successive petitions are disfavored. They're disfavored because they undermine the finality of jury verdicts by adding yet another layer of process to a case that has long since been decided. They are in fact so disfavored that a defendant cannot even file one unless he first obtains leave of court. That requires him to meet either the actual innocence standard or the cause and prejudice standard. And this court has emphasized these are immense procedural hurdles that are extremely difficult to meet. And here the lower courts correctly decided that defendant does not make either one. Now, defendant today, similar to his briefs, doesn't really go through the analysis, the requirements of these. So I think it might be helpful to do that. His actual innocence claim to start with, I know counsel said a lot of things, but the issue is actually pretty easy and straightforward. And that's due in part of the fact that he's abandoned so many of his arguments and his claims. Through most of this case, he tried to rely on affidavits from 3 people. The first 2 were from Stewart and Butler, both of whom testified at trial. And the third was his girlfriend, Davis, who he did not call to testify. In his reply brief, defendant makes clear he is not asking this court to rule on Butler and Stewart anymore. He's abandoned them, which makes sense. They just repeat their trial testimony, which is obviously not enough. So this court only has to look at Davis's affidavit, the girlfriend, but she's not enough either. It's a threshold requirement of an actual innocence claim that the evidence must be new. And new means it was not known at trial and it could not have been discovered at trial. That's fatal to Davis's affidavit because the record is completely clear. She was very well known at trial. Everyone said she was an eyewitness. She was listed on discovery materials and witness lists. She was in a relationship with defendant. And as counsel alluded to earlier in this case, defendant filed a sworn pleading and also a sworn affidavit saying that Davis was working with the defense before trial, and she actually came to trial and is ready to testify on his behalf. So she is obviously not new evidence. Now, defendant, he's kind of quit trying to argue that she's new, I think, especially in his reply brief. So he really has one argument, basically the argument he presented today, that this court should ignore whether evidence is new, that's not really a requirement as long as the evidence is strong enough. That's absolutely incorrect. This court has repeatedly held that newness is a threshold requirement. It's what this court held in Edwards, Bailey, even defendant's own cases. He says without citing any cases, he told you that this court has frequently recognized that newness doesn't matter, but he doesn't cite any cases. I'm not aware of that. The cases he relies on, Coleman and Tyler, they both hold that evidence is not new, the claim automatically fails. And there's obvious reasons for that. If we were to ignore newness like defendant is saying we should, we would be greatly expanding successive petitions. Instead of successive petitions, they would actually be second or third or fourth trials in reality. That's obviously not what the legislature ever intended. Now, this court could just stop there on the actual innocence claim. Davis is obviously not new, so his claim automatically fails. I'd like to briefly mention, though, that it fails for a second independent reason. As this court said in Edwards, at this stage, the motion to leave stage, defendant has to present a colorable claim that Davis's affidavit is so strong, it's more likely than not that it would result in him being found not guilty. As this court has said in cases like Edwards and Coleman, this is an extremely difficult standard to meet. For example, it's higher than the prejudice prong of Strickland, and Davis does not come close. We provide several reasons why that's so in our brief. In the interest of time, I'll just mention one, and that's defendant's own cases show, or excuse me, the own documents that he attaches to his petition show that Davis told multiple people before trial that defendant was the shooter. She specifically identified him as the shooter, as the killer, but she said she was not going to testify against him because they were in a relationship, they were dating, and she did not want to see him go to jail. Now, defendant in his reply brief, he doesn't address this in his oral argument, but in his reply brief, he only has one response. It's not a substantive response, it's a procedural one. He says it's premature to consider Davis's credibility, but that's not the issue, Your Honor. We have never said that this court should examine Davis's credibility. What we have said and what Edwards requires is at this stage, this motion for leave stage, he has to show that her affidavit is so strong, it would result in him being found not guilty. And as Edwards says and other cases say, that question must be answered now. He bears that burden, and it must be based on all of the evidence in the record, which shows, again, that Davis told multiple people defendant was the shooter. One last issue on this actual innocence claim. I think defendant quite rightly recognizes that Davis's affidavit is incredibly flawed. It's meritless just because it's not new, and it's weak on its own. So what he's asking this court to do is that he be allowed to supplement it with some other evidence. He has two claims in this case: actual innocence, which again is just based only on Davis at this point. He separately has a due process claim that's based on allegations that some of the detectives in this case supposedly have a history of coercion. These are separate claims subject to separate tests, but he wants to supplement his actual innocence claim with some of these allegations. Contrary to what he says in his briefs and what he's told you today, this court's precedent makes clear he can't do that. Washington, the seminal actual innocence case, as Washington, I think some of the questioning alluded to this, what Washington is concerned with is factual innocence. It's not concerned with process errors or, you could maybe weaken the state's case. It's concerned with someone who is factually, literally innocent. And as Washington expressly said, you cannot support or supplement an actual innocence claim based on evidence that's being used to supplement or support a constitutional claim, like defendant's due process claim here. Now, defendant acted as if there was only one case following Washington. He acted as if there was only Hobley. That's incorrect. There are two cases from this court directly on point. There is Hobley and Orange. In both of those cases, like this case, defendants alleged that a few of the detectives in their case had a history of coercion. They used that to support a due process claim like defendant is doing here. They also wanted to support it, use it to support an actual innocence claim. And this court quoted Washington and said, you can't do that. Washington prohibits that. Now, defendant's only argument is that this authority was overruled by a 2013 decision, Coleman, but that's incorrect. Coleman does not even cite Hobley. It does not even cite Orange. It does say that Washington remains good law. And it says if you want to raise an actual innocence claim, you must meet the Washington standard, which again, as Washington expressly said, has to be shown by evidence showing factual innocence and cannot be supplemented by evidence related to a constitutional claim. If I could briefly turn to his remaining claim, that's the due process claim based on allegations, again, about some of these people involved in the case have a history of coercion. I know defendants said a lot of different things, but once again, if you break it down, there's not really that much at issue, and I think it's very easy for this court to resolve. We had 4 eyewitnesses testified at trial. They identified defendant as the shooter in written statements that they gave to police and prosecutors, and also in sworn grand jury testimony. They gave those prior statements to 7 people. 4 of them were detectives and 3 of them were assistant state's attorneys. I think it's interesting, defendant does not allege that the 3 assistant state's attorneys have a history of coercion. One of the detectives, Detective Clisham, same thing. He does not allege he has any history of coercion. So really this case comes down to 3 people, excuse me. That's Detective Halley, Forberg, and Foster. Now, originally in this case, defendant relied on 2 categories of information. One was citizen complaints, which are basically complaints a member of the public can file with the police department complaining about a police officer's conduct. I think it's fair to say defendant has either implicitly or just obviously abandoned that as a source of evidence, which makes sense. As the appellate court pointed out, when you look at those, first of all, almost none of them were sustained during these decades and decades that these detectives worked. But more importantly, none of them that relate to the detectives at issue in this case, none of them concern witness coercion. So they're about irrelevant things. So I assume that's why defendant has not relied on them here before this court, doesn't discuss them in his briefs really, and he just gives them brief mention here. So he's really left with a couple lawsuits that he says involve a couple of these 3 detectives. I should mention briefly, the first element of his claim is cause. Cause means he has to identify an external obstacle that prevented him from raising this evidence either at trial or in his first PC. We've explained in our brief several reasons why he can't show that. Just as one quick example, one of the lawsuits he relies on, the Bell lawsuit, that was discussed, it was filed and discussed in the Chicago Tribune way back in 2002. So that was before defendant's trial, years and years before his first post-conviction petition. So he can't show cause, but I think the bigger issue is defendant is forfeited cause. Even though this is a required element of his claim, he does not discuss it in his opening brief. Even though we spend a couple pages in our response brief explaining how he can't meet cause, he doesn't specifically address it in his reply brief. So he obviously can't address it here in oral argument, and I note he didn't anyway in his opening. Turning to prejudice, though, he can't show that either. Courts have said that in coercion cases like this, prejudice requires the defendant to show that there's sufficiently similar coercion that he alleges in his case that we know occurred in other cases. I think, unfortunately, in his PLA and in his briefs, and to a certain extent today, defendant has somewhat misrepresented this issue by saying that the appellate court applied some brand new standard that was overly burdensome because the appellate court, in one small part of its opinion, briefly referred to a strikingly similar standard. First of all, this is not a brand new standard at all. This court referred to it in the Patterson case, used that similar language 20 years ago. Since then, there's been a lot of appellate court cases. We cite a few in our brief, but there's many more applying the same standard. But more importantly, it is not an overly burdensome standard. It's a very common sense, reasonable standard. No one is saying, or the courts have not held, that every single detail must match exactly. What the people are saying and what the courts have held is that the defendant has to show a couple things. He has to show that the same person, the same detective or prosecutor, was involved in his case and the other cases that he's relying on. And he has to show some kind of meaningful similarity between what he alleges happened in his case and what we know happened in the other case. Now, obviously, that'll be somewhat fact dependent, but that's a completely reasonable standard. We don't want to waste judicial resources, especially, again, I would note this is a successive petition. We don't want to waste judicial resources when there's no meaningful similarity. Defendant, I should just briefly mention on this issue, in his briefs, defendant doesn't really clearly, well, first of all, he doesn't cite even a single case applying a different standard than what the appellate court applied. He's never really clearly, I think even today, articulated what standard he thinks should apply. He sort of talks, if I understood him correctly, in his opening, he talked about evidentiary rules. I found that very surprising because I believe in his opening brief, he clearly said evidentiary rules should not be applied, and it would be a mistake to make the prejudice standard and the evidentiary standard similar. So in any event, none of the evidence in this case would have been admissible under normal evidentiary rules.
Counsel, could I ask you this? Did Patterson actually set strikingly similar as a standard itself, or simply make an observation that in that case, the evidence was strikingly similar?
Sure, Your Honor. And I may have misspoke. If I did, I apologize. I think in our briefs, we were careful to say, I don't know that it's fair to say Patterson said this is the exact standard. Certainly, Patterson and Orange, which dealt with similar issues and cited Patterson, both clearly said that generalized allegations are not enough. So I don't know that it would be fair to say they expressly adopted the strikingly similar, but they clearly said that a generalized allegation is not enough. So we are certainly not wedded to a strikingly similar title for this standard. What we are asking this court, saying that was correctly applied here, because it's just a reasonable standard. There just needs to be some kind of meaningful similarity. And in this case, Your Honor, no matter what standard we apply, whether it's what the appellate court applied or whatever standard defendant is now saying should apply, defendant can't meet it. I think it's interesting if you compare the parties' briefs. We, the people, were very careful to go through every single eyewitness, very carefully explain exactly how they alleged they were coerced in this case, and then very carefully explain how that's not similar to any of the prior allegations against these three detectives. And if you compare that to defendant's briefs, he makes no attempt to do that. He never specifically tries to explain how these allegations were supposedly similar in any way. Just to take a couple quick examples, I know he mentioned a few people today. One of the eyewitnesses, Shamika Mason, she's the first eyewitness. She doesn't really complain about how she was treated. It was a very relatively quick interrogation. You know, she wasn't denied food, water, or anything. What she said is that she was facing a bunch of drug charges, and police told her, look, if you work with us, if you're willing to testify against him and sign this statement, we can help you out with that. I don't know if that counts as unconstitutional coercion, but it's certainly not similar to anything that this defendant has identified. Just one more quick example, Vernon Clay, who he did mention. If you look, I don't know that counsel really captured what Vernon Clay said. Vernon Clay at trial told this completely ridiculous story that he was brought to the police station. They just left him there for a while. No one talked to him about the case. Then they came in and they apologized to him. They said, we should never have brought you in. We've talked to a bunch of other people. Everyone agrees you weren't there. So we're going to get you out of here, but you need to sign this property receipt. And then they put a 5-page document in front of him. He says they covered up all of the text of the document. They said, just sign the bottom of every page of this document. If you look at the document in the record, you actually see not only did he sign at the bottom, I think he signed in the middle of one page and on initialed some other things. Then he says, well, then I found out weeks later that was no property receipt. That was actually a statement implicating my fellow gang member. That's a ridiculous story that would require multiple people, including an assistant state's attorney, to commit fraud. But more importantly, it's not similar in any way to the allegations against anyone in this case. The defendant cannot seriously argue that it is. Finally, if I could just mention a few things. I think we've tried to be very careful about this in our brief, but defendant is really focused on a couple of the lawsuits that involve some of the detectives in this case. We would urge the court to look carefully at those lawsuits and look carefully about the briefing on those lawsuits. A lot of the things that defendant has tried to argue, either in his briefs or today, is incorrect. There's a couple cases that he didn't mention today, so I'll just leave them to the aside because he didn't really focus them on his briefs either, although we explained that what he said was incorrect. But I would like to focus on the Bridewell case because that's what he's focused on really throughout this case. The first thing defendant told you about that case is that In that case, Detective Forberg stipulated to this terrible interrogation, this wrongful coercion of a witness into falsely implicating someone who is completely innocent. We've cited the district court opinion in that lawsuit, Seventh Circuit opinion. If you read that, far from stipulating to this claim, as defendant said, Detective Forberg fought those charges and he won. Now, defendant said he won for procedural reasons. I do not know why defendants keep saying that. The district court specifically found that the claim was meritless. It was not a procedural basis. The next thing he told you about that case is that the suspect in that case was completely exonerated, that prosecutors determined the person was completely innocent. I do not know why defendant keeps saying that. If you read the Seventh Circuit opinion, the Seventh Circuit specifically rejected that argument. As the Seventh Circuit pointed out, the suspect in that case actually entered into a plea deal. Prosecutors, far from exonerating this person, there was all sorts of evidence that this person was guilty, including not just multiple eyewitnesses, but forensic evidence. Defendant has also, I think, somewhat not accurately stated a few things. For example, he says in that case that, for example, a fraudulent polygraph was used. Again, that's based on a meritless claim. But the witnesses in this case, if you look at what they said at trial, or if you see what they said in their affidavits, they don't say I was coerced by a fraudulent polygraph. So not only is it based on a meritless claim, it's not similar to what occurred here. So the fact that defendant unfortunately is not accurately stated the facts of this case, I think speaks to the weakness of his claims. So unless this court has any questions, we would ask this court to affirm the appellate court's judgment. Thank you.
Thank you, Mr. Cebula. Mr. Clark, rebuttal. Unmute your speaker.
Sorry, Your Honor. Thank you. I'd like to start by answering a question that I think Justice Burke asked about the Patterson decision. The Patterson decision, read in context, definitely did not lay out a litmus test type standard for strikingly similar evidence. The closest to that I could characterize Patterson is that it laid out a multi-factor, quasi test for indicia of reliability. It specifically stated that the allegations were consistent over time, that they were corroborated by allegations in other unrelated cases, that they were corroborated by an official inquiry, the OPS report involving the Burge torture ring. And then finally, that certain aspects of the allegations were strikingly similar. Mr. Jackson very clearly satisfies that standard, if indeed it is a standard. His allegations have been consistent over time, ever since the trial, ever since before the trial. All of the witnesses have stated they were coerced into giving these statements, that they were not true. It's corroborated by all of the other allegations, whether proven or not. In Patterson, many of them weren't proven. And here, as counsel correctly points out, many of the CRs against these officers were not sustained. We have our view as to why that may be. I'm sure counsel has his, but in any event, there are allegations that corroborate the current allegations. There's an official inquiry here in that the detectives, or at least one of them, stipulated a conduct in Bridewell in a federal court case. The stipulation is not to be taken lightly in any court. And I believe we've cited a number of cases in our brief as to why stipulations in one proceeding should be admitted for substantive evidence in another proceeding. And then finally, they are similar, as I walked through earlier, the similarity between the allegations of the witnesses here and the witnesses in Bridewell. So I hope that more fully answers Your Honor's question. I'd like to turn to the rest of my rebuttal now, unless there's follow-up on that. Thank you. So I find counsel's case argument incredibly troubling when it comes to discussing issues of fact. Certainly, we have very different views of what qualifies as a fact in this case. For example, counsel states without reservation that Ms. Davis was defendant's, Mr. Jackson's, girlfriend. The only place that exists in the record are in statements that were allegedly coerced. And I've just run through all of the ways in which our allegations of coercion should be credited for the reasons expressed in Patterson and otherwise. And yet counsel repeatedly states things out of the record as though they were true facts. What's happening here is that Mr. Jackson was convicted, and therefore all of the facts that support the state's theory must be true, and all of the facts that don't are misstatements of fact. And I recognize that that is an appropriate means of argument. However, I find it very troubling. We have alleged facts that support Mr. Jackson's claim of actual innocence and his claim of cause and prejudice, and they should be taken on the basis of their allegations. They're well-pled allegations. This court has been incredibly clear throughout its history that post-conviction proceedings proceed in step, that at an earlier stage, there's a lower showing necessary. At a later stage, there's a higher showing necessary. And many of the facts that, I say facts with quotation marks. I hate to be so informal, but the facts such as they are that are alleged by the state are facts that can be borne out at a new trial. They have no basis in these proceedings. We are asking, I will admit, we are asking for this court to expand the rules the ways by which a petitioner may support a claim of actual innocence. Ms. Davis's testimony was known at the time of trial. There's no doubting that. And her affidavit in 2007 and her affidavit now are incredibly similar. And I urge your honors to review the two of them side by side. I do not find there to be any conflict in what was stated previously in 2007 and what was stated in 2017. She was known. She could have testified. Our point is that she should have testified. And Mr. Jackson's 2007 post-conviction petition specifically raised that. He said he wanted her to testify. His counsel didn't call her, and that was ineffective. And it was because, contrary to what the state has to say, her testimony would have changed the result at trial, and it would on retrial. She had no prior inconsistent statement, coerced or otherwise, with which to impeach her at trial. She would have been able to state without impeachment that Mr. Jackson was not there, that she knew him, she grew up with him, she would have recognized him, he wasn't even present. And she also would have corroborated the misconduct of the officers that all of the other witnesses testified to. And the first district below was correct in its ruling that it was material, it was non-cumulative, and it was conclusive. The only reason for the first district's decision, if you go back and read it, and I urge your honors to do that, is that it was not, quote, newly discovered. This court has a long history of expanding the ability to bring actual innocence claims. In Washington, it broke from the Supreme Court, US Supreme Court. In Patterson and Coleman, it relaxed the standards to admit exculpatory evidence. Not as far as we're asking today, I admit, and I believe our briefs have been consistent on that point, but has expanded the ways in which exculpatory evidence can be introduced. In Ortiz, it excused claimants alleging actual innocence from showing cause and prejudice. This is no doubt an expansion of the law, but it is one that is warranted. If I could, I would leave your honors with a quote out of People v. Warren, which is a first district opinion, and of course not binding on your honors, but I think that it is a message to leave you with. And that is that if the principle of fundamental fairness creates a floodgate of these sorts of cases, we should not only accept it, but openly welcome it. I thank your honors.
Thank you. Case number 124818, People of the State of Illinois versus Kevin Jackson. Agenda number 4 will be taken under advisement. Counsel, Mr. Clark and Mr. Sabula, thank you for your arguments this morning. Mr. Marshall, the Supreme Court stands adjourned until 9 a.m. until tomorrow morning at May 13th.
The court stands adjourned until tomorrow morning, May 13th, Wednesday, 9 a.m.